Yes. Yes. Today we are here. We are here to discuss about the intellectual property, the property which everybody should own and which should be a vital part of research career. So here we are going to know our rights. Know our rights here regarding the intellectual property. So this is the overview, what we are going to see today, the law governing the IPs and the meaning of the intellectual property. What are the types of intellectual property available? That is patent, trademark, copyright, and we have the geographical indications also, and the infringements, and coming to the case studies, and finally we are here to conclude. This is our agenda today. So we need to know about WIPO. This is the World Intellectual Property Organization, which has been established by the WIPO Convention 1967. WIPO is actually a specialized agency of the United Nations, and what they do is that they promote the protection of the intellectual property throughout the world, and their headquarters is situated in Geneva, Switzerland. This is what we need to know about WIPO, the World Intellectual Property. And this is month is actually about the intellectual property month, April, and specifically on April 26th is the World Intellectual Property Day. And what is their vision on each and every year? They need to update their vision, and more or less it is going to talk about the innovation. So the visionary innovation is a key feature. So the World Intellectual Property Day is celebrated on April 26th. So about property, we know there are two types of property, the tangible property and the intangible property. The tangible, we can further divide it as movable and immovable. Movable, we can take the example as car, and immovable, we can take the example as building. And this is a very important another aspect called intangible property, which cannot be separated. That is what we try to insist today. This is a property that nobody cannot take from us. It is going to be our intangible property, very worthful property we need to have rather than the tangible property. So the intangible, it is the intellectual property we speak about, and further classified as industrial property related and copyright related, whereas the industrial property related could be said as patent, design, trademarks, and geographical indications. So industrial property related, all these, they need to have an innovation part or a novel part, whereas the copyright related, that doesn't need a novel one. It needs the expression of idea that is going to be unique then and there, not the idea. But here the patent, design, trademarks, and geographical indications, it is going to be a unique one, a novel one. Copyright is the expression of ideas, not the idea. That is the main significance we need to know here. So with this model, I hope we'll be able to better understand the patent, design, trademark, and copyright. So when we take this car as a model, when we talk about the working mechanism of the car, we can say it as a patent. The working mechanism, how it is going to work, we can take that as a patent. And when we talk about the shape of the car, we can talk it as a design. So the working mechanism is going to be a patent. The shape of the car is going to stand for the design. So the name of the car, that is going to be the trademark. What is the name of the car? It is the trademark. And the manual, it is going to be the copyright. This is what we said. This manual, it is not going to be a novel idea, but the expression of the idea, how the manual is being given. That is what we call it as a copyright. So this is patent, working mechanism, design is the shape, the trademark is the name, manual is a copyright. So the IPR, the intellectual property, so it is of patent, it is of copyrights, the geographical indications, the industrial design, the trademarks. This is IPR. So an exclusive right is going to given to a person as they have the creation of their mind for a certain period of time. Exclusive rights is being given to the patent holder. So they will be having the legal right for that property. It is going to be an intangible potential asset. Yes, and they are going to stand as a monopoly. The patent holder, he is going to have all the rights, monopoly. So the negative thing what we want to say is that it is going to prevent others from using the creation for a certain definite period of time because it has been holded by the patent holder. So others cannot use that particular idea, which stands as a negative one. So this is about the overview. So where it has been located and other stuffs is being given here and here in the slide. The Ministry of Commerce and Industry, the Department of Industrial Policy and Promotion, it comes under the Controller General of Patents, Designs and Trademarks, and further divided as Patent and Design Office located in Calcutta, Delhi, Mumbai, and Chennai. And trademarks, it is going to be of Mumbai, Kolkata, Delhi, Chennai, and Ahmedabad. And the Geographical Indications Registry, it is going to be in Chennai. The patent information system, it is in Nagpur and other stuff. So this is going to be the places where it is being located. We need to know about this as we need to know what is patent and other stuffs. We can see all these places where it is getting located. So with this Coca-Cola bottle, we can further very much clearly get to know about this trademark and other stuffs. This logo, this is going to be stand as the trademark. Yes, it is going to be the trademark for that particular product. This is the trademark, the Coca-Cola, the wordings, the logo, how it appears, the font, the size, everything matters. And then we can talk about the shape of the bottle, how it is. The shape of the bottle, it is going to be the industrial design. And then patent, we can claim patent for the bottling equipment, how it is being bottled. The bottling equipment can be claimed as a patent. And copyright in respect of the text or the database or the artistic work which is going to appear on the website. So for a single product, we can protect it by more than one IPR. Yes, this particular single product can be claimed for trademark, can be claimed for industrial design, can be claimed for patent and copyright. But in various aspects, this is what we are trying to say, the different aspects of the intellectual properties. What are the different aspects? So a single product can be protected by more than one IPR. Yes, it is possible. And when we talk about the another examples of these patent, trademark, and other stuffs, this fan, ceiling fan, the how it is being working and all these things, we can take it as a patent. The same wise, the mobile phone, how it is going to be worked, can be taken as patent. And this logo is a trademark. Yes, this is a trademark as we have discussed. And we can see the industrial design of this particular fan. It is going to have an unique design which has been claimed as an industrial design. And again, this bottle, this patent, the bottling equipment, the design, the shape of the bottle, industrial design, the logo, the trademark, and this is going to be the trade secret, the shape of the bottle. And coming to another steps, what we are speaking about is a geographical indication. As the name indicates, it is going to indicate the product with the geographical place where it is being located. So this is a chapel, we all know, but it's going to say it as a Kolhapuri chapel, the geographical indication, Kolhapuri chapel. So geographically, it is getting indicated that it has been from Kolhapuri. And I think all tongues will be tangling on seeing this, I hope. Laddu. Yes, and specifically Tirupati Laddu. So geographical indication again here. So this laddu is being indicated geographically as a Tirupati laddu, which is going to be world famous. So the exclusive right is against the unauthorized copying of the trade secret or the trademarks. And protection is normally lasts for an initial 10 years, and after we can renew it, and most cases up to 15 years. Probably after that, probably no need, but it's not going to stand good all the time. A certain product, we need certain updates. People look for updates and people look for new things, we suppose, isn't it? So that point of time, mere 15 years will do good. But for certain things, if you want to renew it again, yes, we can make it. No issues in that. So these are all the certain trademarks and trade secrets, this particular jewelry, the shape of the chair, this again, the automobile things, and All these stuffs is going to be the trade secret, and they are going to get exclusive right, whereas from unauthorized copying, others cannot copy the product. So these are going to be certain other things. These things we can say this is going to be the consumer products. So all these are going to be the consumer products, which is going to stand with the trade secret. So others cannot copy it. So each is going to be unique in its trade secret. So others, unauthorized copying is not encouraged here. Again, the pharmaceutical products, these are all going to be the same here. So all these pharmaceutical products, again, it cannot be copied. So all stands on its own. Everything stand on its own. The same way the textile and jewelry also. So it is going to be unique for that particular company. They would have been got the trademark. They would have been registered with the trademark, by which unauthorized copying is not encouraged. And here the company's logos and other things, you all very well know this. So seeing on that logo itself, we'll be able to identify what it is and whose trade is this. So everything is going to become the trademark and it will be registered properly. And coming to the geographical indications, and rice, it is going to be held up with the basmati rice, geographical indication, and tea, a very tangling tea, again the Darjeeling tea, and all women will fall in love with this, the Kanchipuram silk saree. Everybody will fall in love with this, and the Alfonsa mango, and Nagpur orange, Kolhapuri chapel again, Bikaneri bhujia, and Agra pita. So all these is going to be indicated with the geographical place where it is getting existed. So it is being indicated with that particular place. So the intellectual property, it refers to the creation of the mind. Yes, it has been raised from our mind. So it talks about the invention, brand names, secret formulas, content on the website, movies. So everything is going to be the intellectual property. So the types, again, the patent, which is dealing with the inventions. Patent is going to deal only with the invention, and the trademarks, with that we'll be able to identify the product or the services very well. Seeing on the Google, the trademark we'll be able to identify it as a Google. Yes, and copyrights, it is going to be the expression of the idea, how the ideas is being expressed. And talking about the trade secrets, the secret information with commercial value, which we call it as a trade secrets. So what can be patented? Yes, a very important question. So anything under the sun that is made by man, very importantly, it should be made by man. So anything under the sun, anything. So whatever you see it with your intellect, and you will be able to identify any new points over there, any new innovation over there. Yes, very well we can do. So whatever we see, we should see through our intellect. That is very main, because they have answered what can be patented. They have answered anything under the sun. Yes, so whatever you see, find some novel ideas over there and it's going to be patented. That's it. So what can be patented again? Anything new and which is going to be useful. And methods, machines, composition of matter, manufacture, yes, very well. And what cannot be done? This cannot be done. Mathematical algorithms, laws of nature, and ideas. Yes. These things cannot be patented because already existing. We need a novel idea, isn't it? We have seen it is going to be novel. That case, these cannot be patented. Yes, we need to jump over it, everything. So what is that? So requirements of patentability, it should be a utility based one. It should be utility based one. Yes, check. We have done this. And if it is going to be a novel idea, novelty is there. Yes, we have jumped over this also. and it is going to be non-obvious and enablement. That is, further, it can be given as an industrial design, which we call it as an enablement. That novel idea could be made as an industrial used mission or product or whatever it may be. That is what we call it as an enablement. So all these things we need to move through: the utility, novelty, non-obvious, enablement. So the process of the technology commercialization, what we do first, we need to research for a particular idea. An invention must be disclosed and it is going to be assessed, and we are going to apply for the patent, and we are going to identify the potential licenses, and licensing is being done and commercialization is done. And the process of technology commercialization, the invention is going to be disclosed and assessment is going to be proceeded, and we request for the additional information or waive to the inventors, and the provisional patent application is getting submitted and assessment is proceeded again, and we waive to the inventors. If we needed to have any information further, we can waive to the inventors, and the non-provisional patent application is being released. And the IP strength, it is of the patentability search what we do, and the market potential is going to be the market size, and the growth potential what we are looking for, and competition, it is going to be based on the advantages and the new features, and commercialization, whether additional resources would improve the prospect of the commercialization. Any additional resources we can add to it, thereby which commercialization could be done better. And the market need any interest from the target companies. If we are giving any idea and that particular idea is going to be used for the target company, they are looking for that particular idea. Yes, that is the market need. So how to select a trademark? Actually, it is going to be of two things: non-distinctive. Yes, no protection needed because it is not distinctive. When it is going to be most distinctive, full protection is needed. Yes, we need to safely protect that particular trademark. That trademark must be safely protected because it is going to stand most distinctive. And when that it is not at all a distinctive one, yes, we can feel free. No protection is needed. For example, the most distinctive one we can look upon, if it's going to be fanciful, it is made up fanciful. For example, Exxon need to be protected, fully protected. And when it is going to be arbitrary, what do you mean by arbitrary? Means existing word, but is not going to contain any relationship with that particular product. It is existing, but it is no way connected with the product, that we call it as arbitrary. For example, the Apple computers. Apple is not going to do any job with computer, but this is the arbitrary word. And next, suggestive. So as the name indicates, it is going to suggest the product. Suggest the product. It should be fully protected. For example, PlayStation. And it's going to be descriptive. Yes, it is going to describe a product in a better way. That is creamy example. And generic name, that is, it is going to be a common name. For example, soap, phone, so all these things. So when it is going to be falling under these categories, when it falls under these categories, it is becomes the most distinctive one, and it must be fully protected. And the intellectual property law in India, how it is. We have a many big and small intellectual property law firms worldwide. For example, India, USA, UK, Chicago, etc. They provide a qualitative help to the inventors and the creators of the product. Qualitative help is being provided to them. So in India, the intellectual property rights are safely protected and controlled by well-established statutory and judicial framework. They purely take care of it. So, and apart from that, we have many attorneys and law firms of intellectual property in India in various states. Yes, we do have it. So what is intellectual property? Means it's going to be a property that arise from the human intellect, and it is going to be a product of the human creation. And the intellectual property is going to comprise of two distinct forms. Number one is literary and artistic work, and next is going to be the industrial property. It is going to have two distinct forms. So the literary and artistic works, it is going to be of books, paintings, musical compositions, plays, movies, radio, TV programs, performance, and other artistic. So everything comes under this. So how we need to protect all these means we can protect it through copyright. Yes, all the book stuffs, the paintings, and all these stuffs can be protected by copy, because all these, so plays or movies, whatever it may be, the idea may be same in certain movies. Again and again, it's going to be same. So some paintings is going to depict the same. For example, the culture of India, it could predict the culture of India paintings. But in that, for example, 50 people or giving the pictures, giving the paintings for the culture of India, what is the thing is going to be different among them is it how they express their ideas. Idea is about the culture of India, but what is happening here is that the way the painters have painted, the expression is going to be different. That is all we call it as a copyright. So the industrial property describes the physical matter, that is, it's going to be a product of an idea or anything for the commercial purposes, concept for the commercial purposes. So how it is to be protected means by patenting the object or through trademark or through your industrial design, by trade secret, layout design, and geographical indication. Any of these way we can protect all these things. So the major types of intellectual property is going to be the functional and technical inventions. We call it as a patent, and the purely artistic work, we call it as a copyright. It is going to be a symbol, word, sound, color, or design. We call it as a trademark. So the Patents Acts we have in 1917 amended by 1999 and 2005, and Copyright Act 1957 amended in 1982, 84, 92, 94, and 99. Yes, we need to know all these things when it is being amended and other stuffs. And when it is going to be the trademark, the symbol, logo, word, color, or design, it is going to be of the trademark 1999. It has been amended in 94, 96, and 2000. It has been amended in this way. So these are going to be the major types of intellectual property. So, and finally, if any volunteer, you can please do interact. I'll be very happy with this. If you don't find any problem with this question, we need to talk about the types of IP again. Yes, what is asked by them was, all I asked was, yes. One second. So it has been asked, all I asked was, can I patent my copyrighted trademark? That is being asked by them. And the person who is listening to this question, yes, he doesn't know what to do. He doesn't know what to do. So any volunteer who could join hand with me to answer this? Yes, he's getting this reaction after listening to this particular question. All I asked was, can I patent my copyrighted trademark? Anybody? Any volunteer? Or at least in chat box? Any volunteer? Any volunteer? In chat box at least? Okay, fine. So, what is asked being is that all I asked was, can I patent my copyrighted trademark? We have seen the car example and other many examples through which we will be able to understand better that patent, copyright, trademark, all are going to be different, isn't it? So this question cannot stand good here. So next, So the patent is going to be covered under the act called Patent Act 1917, amended by Patent Act 2005, and is going to extend to the whole of India actually, and shall come into force on such day when we file it. So everything, all IPRs, all the intellectual property, it is going to stand from the time, it is going to be claimed from the time when we file on it. That is more important for all the intellectual property. And the patent is going to describe an invention for which the inventor claims the exclusive right is being claimed by him. An invention is going to be patentable only if it is going to be a novel idea, a useful one, which is not going to be obvious and pertains to patentable and is going to be a subject matter. So the patentable subject matter means the invention, which is going to relate to a process or a product, or it could be both process and the product. Yes. And it should involve an inventive step. The novelty must be there, and it should be capable of industrial application. Further, it should be capable of industrial application. We need to take that novel idea to an industrial application in future. And mission. So the life and duration of the patent is for 20 years from the date of filing for all types of invention. The priority date is going to be first when we file. The date of the patent is going to be the date of the filing, and the term is going to be counted from that particular date. And when we talk about this patent, I need to share that another one. Let me share one thing. Please do acknowledge me whether it is visible. My screen is visible. What I'm going for the intellectual property, that website, is it visible?
No, ma'am. Only life and duration slide is visible.
Yes, sir. I'll share that one again. Now it is visible, I hope. Is it visible now?
Yes, ma'am. It is visible.
Yes, and I'm sharing this in the chat box also. If people you wish, you can move on to that. I have shared the link in the chat box. So here we can see the patent, the design, the trademarks, and geographical indication. This is going to be the government one, intellectual property.
No voice, madam. No, ma'am. I think there is an internet issue. Please wait for 1 minute. There is an internet issue with the ma'am's office. Please wait for 2 more minutes. Ma'am will join. Sorry for the inconvenience. Just 2 more minutes. Ma'am is trying to rejoin again.
See people, their ideas, and from that we'll be able to understand what are all they have done, how to write the claims and how to make the drawings and how to do the abstract, the usual way what we do for the journal publication, the paper we do the same we can adapt for that. Also we can see the people idea, and from that we can find any novel things. If we can find, so for example, any title, for example, IoT in agriculture. If you want to give, we can give, and we can search what are all the things given. IoT in agriculture, you have to give any title, what is your title required, and we have a captcha code here, and we need to give that captcha code. And after giving the captcha code, when we move for search, we will be able to see this related to agriculture. So with those keyword IoT and agriculture, with those two keywords, it will be searching and will be giving you all the steps what is available. For example, real-time agriculture field monitoring system using IoT. So it has been the application date is on April, and it is published. The status is going to be published, and we can see that particular title and what the inventors have given, what is their abstract. And we need to fill 4 important forms for the patent. So which is going to say about the inventors and the applicants, that is who has applied for it and who are all the people involved in that particular invention, it will say. So for example, these are the people. The date of filing is going to be 5th April, and it has been published on 15th April. It's a fresh, we are seeing it right now. The field of invention is going to be science, and the applicants are going to be these people or the application, and they say for real-time agriculture field monitoring using IoT, and these are all the states. So we need to file it, and just publish, and the request is be filed for the examination, and finally it will be disposed. These are all the stages. So that is what they're telling us, awaiting request for the examination. And when we give on this view documents, and now once it is being published, it will be available globally, thereby which any people listed on that this particular thing, they can see those things. So for example, this is what I say, these forms need to be filled, and other things we need to fill it on form 1 and form 9, form 5 and form 3. These are all the important forms we need to fill it up. So for example, when we go for this particular drawings, we can see what are all the drawings they have given and what it is going to relate with that particular pattern, the idea they are giving. So everything is going to be available in this website, and you can go through this and you can find out your novel idea from the existing one also. So thereby which the existing one, it is available, but even then you are finding some important aspect from that which is going to be new, or anything novel you are going to be specifying from that particular idea. Yes, it is possible, we can do all these stuffs. So this is what they have given: proposed invention functional flow diagram. This is their diagram what they have given. We are going to say something out of this cloud layer, edge layer, then this physical layer, network layer. So artificial intelligence, machine learning, virtual servers, big data analytics, internet cloud here, and cloud to cloud, and using edge gateway, edge to edge, real-time monitoring is happening here. And here we have all the smart devices that with the greenhouse is available, and all these animals and other for the farming, everything is being available, thereby which we can identify the steps. So when we see about any complete specification, we can see the complete specification also, what are all the abstract and claims is form 2, all the people, and what is the field of invention. So it be field monitoring system using Internet of Things using IoT, and the background. This is going to be related to literature survey, what we do, what is the background of the invention, and modular smart implement for precision agriculture, what you need to do for that. Here tract is given. So how it is going to be for smart agriculture management. So all these literature survey will be given here, and the summary of the present invention, what is their present invention they have given here. So like this you will be able to go through all the stages available, and we can find a novel idea. This is what detailed description of invention. So everything will be given here. What is the sensor layer, what it is, middleware design is being done. Complete information will. So what is their claims? What they claim is available. That's it. So like this, we'll be able to get all the things which is available. So everything. So everything is going to be available globally, thereby which we can find out our things what we are in need of, and we can move on with that. So the life and duration. And when we talk about the life and duration, the term of the patent is going to be for 20 years from the date of filing, and the priority date always it is from the date when we file it. And the fees for the filing patent, and now it has been increased to 4,500, and it is going to be the fees for first and second year, we don't need to pay any fees, and renewal fees is going to be from the third year onwards till the 20th year. It is for to keep the patent in force, because for 20 years it is going to exist. Patent will lapse if you are not paying the fees within the prescribed period of time. We need to do it. So this is another important doubt many could have. So if a patent granted in one country is enforceable in other countries, and thereby again, if the patent is refused in one country, it is going to be enforceable in other. Yes, it is not that case. Whether it is granted or refused in one country, it is not going to stand the same for the other countries. There is nothing like a global patent or a world patent. Yes, nothing like that. You cannot have any global patent or world patent. The patent rights are essentially territorial in nature, actually. So, granting a patent in one country of the union does not force other countries to grant the same patent for the same invention. They cannot force that also. The same way, the refusal also in one country does not mean other countries also will terminate it. It is not that case. So the patent holders in India, the list of top 10 patent holders in India, they comprise only of the pharmaceutical and the biotech companies. In India, actually 184 patents are held by the Council of Scientific and Industrial Research, followed by RAND Baxi. They hold 184 patents. And while the top 10 patent holders across the world, when you talk about across the world, it is of IT companies. But in India, no IT firm has their patent. I'm very happy to introduce this particular person who is on the wheelchair bound. This is the youngest patent holder of India. He is the youngest patent holder. Hope you all will enjoy seeing him. So Jaipur, it is situated in Jaipur. His drawing inspiration is scientist Stephen Hawking. He's a wheelchair bound 9-year-old boy who has invented a game actually is it is of 6-player circular chess he has invented, and his name is Rideshwar Singh Bhati, and who has got the game's design patented in his name itself. So he's the youngest patent holder and very importantly a wheelchair bound boy. Hope you all enjoyed seeing him. It is a model certificate agency. And coming to the trademark, which is going to cover under the act called the Trademarks Act 1999. The act came into effect on September 15, 2003 and replaced Trade and Merchandise Marks Act of 1958. So it is going to extend to the whole of India. It shall come into the date where it has been done. The first date where it has been filed. From the date itself, every patent, every intellectual property is going to be stand from the date when we have filed it. So the trademark, it could be of symbol, logo, word, or any sound, color, design, or any device that is used to identify the business or a product in commerce. Yes, seeing that Google we can see, seeing that other stuff, BMW, like that, everything is going to stand with the trademark. So different symbol what they use is that they use the TM, which is going to be filed for the product. And if it is for SM, it is filed for the services what they give. So the registration procedure the same. It is going to be applied for the search, applied for the registration, and examination mark happens and advertisement happens. And if anybody who wants to file for opposition, yes, very well they can file for the opposition, and certificate is issued finally. So the duration fees, the trademark is going to vary for 10 years, and we can extend it further a bit of 10. Paying the prescribed fees, we can extend it another 10, and the service mark rights is for the owners of 17 years, and it can be also renewed again. The government fees is going to be 2,500 for the class of goods and services. So the applicability is that trademark is a sign it's going to be used on the goods or the services we are going to use on that. So used on mean the good which is going to appear not only on the goods themselves but on the container or the wrapper in which it is going to be sold, the goods is going to be sold, it will be appearing. So we call it as a used on. So for example, this Raymond textile we have seen, this is going to be correct usage, and this is not going to stand good. This is not the correct usage. So this is a trademark. So it is going to specify the font, the size, the proportion, and the placement. Everything matters in the trademark. This is the correct usage, whereas all these things are not going to be the proper usage. So we are not supposed to change the spelling also in the trademark. Calvin Klein, Tommy Hilfiger, these are going to be the correct usage, where these are not the correct usage. And the trademarks, we have seen the name, the logo type, the symbol, the slogan what we use, the shape, the color, everything is going to be the trademark, and nothing should be changed and nothing should be copied. So when it is being copied, it is going to become as an offense. We are not supposed to do it. The copyright, the Indian Copyright Act of 1957, and it has been amended in all these years. So the term original for the copyright, it is going to be the novelty or the uniqueness in the copyright. It is the expression of the idea, not the idea actually. How it is being expressed, that is the originality in copyright. So what could be covered in copyright means literary, films, dramatics, artistic, musical, won't be copyright, which not coming under copyrights means the ideas, the facts, the recipes, works lacking originality, and the names, title, and short phrases, these do not come under copyright. Procedure is again we need to fill up a form, a simple application form, and we need to send the copy of a work, and finally copyright protected. So the duration is going to be author's lifetime actually, and moreover after author's lifetime plus 50 years, and is going to be stand from the calendar year. So, on 50 years for films and sound records, in 25 years for typographical arrangements. So, what is fair use actually? So, when we public exclusive right for purpose, it is fully learned everything. And what is fair usage? People can use the copyrighted material if certain criteria are met, and it is going to be the product of freedom of speech. And mainly in our wing, it is available the education wing. It promotes the public benefits like education. It is a fair usage. So we also need to know about the fair use excuse. Never assume that the whatever you use falls under the fair use exception, and saving money alone is not a sufficient excuse actually. Laziness can also be a trap here. So how much we can use means regarding the photos and images, up to 5 works from one author you can take, or up to 10% of 15 works, whichever is going to be less. We can choose that. And regarding the database information, up to 10% or 2,500 fields or cell entries. And again, whichever is going to be less. So what are all the action which is going to be taken again, the infringements? So what constitutes infringement actually? Any reproduction or usage or distribution performance, etc. of the work without the permission of the owner, we call it as an infringement. So any identical or substantial, which is going to be similar reproduction, is also covered here. An infringement is the damage or the injunction. What are the remedies for patent infringement? A suit can be laid in the district or high court, and they can issue an injunction either to prevent the infringer from any further use, or they can award damage the patent owner, or they can pay the royalty for the further usage. In these three ways it could be done. So Apple sued HTC over iPhone patent actually. So Apple sued phone maker HTC and has filed a complaint with the US International Trade Commission, alleging that the Taiwanese company is infringing 20 Apple patents related to the iPhone. So the Steve Jobs, Apple CEO, what he says in a statement is that we think competition is healthy, but competitors should create their own original technology and not steal us. It is the thing given by him, the statement given by him. Immediate trademark infringement is that the suit can be aligned. The infringement could be from 6 months to 3 years, and permanent ban also could be made in engaging any commercial activities in future. So the example of successful enforcement action is the 3 filed by Adidas, Solomon, Delhi High Court against the competitors. So at the initial stage, infringing goods were seized by the local commissioner, and the cases were decreased recently, and damages of rupees 15 lakhs was awarded to Adidas Solomon. It has happened. And when we talk about the copyright infringement, again a suit can be lied and can punish it for 3 years and more. And certain things, all these things as limited, but whereas other people they copied the same work by Ashwini Kumar, by Naina Talukar and Sajid Mobain, they have copyrighted this work. It has been given a copyright and they have claimed. So this also is going to be the infringement. And sometimes we used to say, I didn't know, but I know, like that we used to say. So it occurs when the infringer was unaware that things were protected. Actually, they're not aware, but excuse cannot be given when the work is going to be displayed properly as patent or the trademark symbol we have seen registered, the TMSM we have seen for the trademarks and services and the product we have seen, and the copyright note, for example, Uts of sarees, copyright like this. So if it is going to be clearly displaying of all these things, innocent infringement cannot hold here. Conclude finally is that we need to create ourselves rather than using others' creations. We need to create ourselves actually, and we are not supposed to use the competitor's marks in such a way that it harms the competitor in any unfair way. No comparisons that are likely to cause confusion. No comparisons should be that. And the technological advancement made the job of the creator easy actually. It also made the job of the copier also easy. That is what we need to conclude here. And over to the organizer, if anything need to be clarified or anything need to be asked, we can ask here, or if no such things, we can wind up organizer. And I'm sharing my contact details here. If you want to contact in future also, we can do.